Can I provide our if you wanna like in a Marisal? 9. Bagan I don't
Okay. Permitted.
Please, Your Lordship, I'm praying for the listing of a writ petition. It's connected with item 60 today. Because it was to be listed today by an order of this court. Unfortunately, it didn't come out. But I'm praying if it can be called for because it arises from the same contracts, which can be perhaps taken up together.
Okay. The prayer for listing, give it to the court master, please. All of them. Give it to the court master.
May please.
Yes.
I can have 50 minutes. 50.
50. Content matter?
My lord.
Yes.
The matter may be taken after 2 weeks, my lord. I have to take instruction from the client.
Okay.
Item number?
You have informed the respondents?
My lord.
You have informed the respondents? No. Then renew the prayer when the matter reaches. Correct. Civil counsel, you can inform somebody and then make a mention. No ex parte mention. Yes. $40. 48. 48. Okay. Password for the day is created for by counsel for the petitioner. Yes.
That is a lordship. Lordship, I let you mention item number 61 supplementary. This matter was a team paper representing out of session. 61.
61.
61. We've taken consent of the side, lordship.
You have informed the other side? Okay. 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 Both sides are represented on the prayer made by Mr. R. Goway, Standing Counsel for Forest Department. Matter stands adjourned today. List on. Give a fixed date after a week.
22nd. 22/11.
24th.
24/11.
Okay.
All right.
Button up your court. You can't open the court and then submit. Yes.
Out of state. Some accommodation may be given today. The matter will be 4 for 6 of December.
You have taken consent of the other side? Okay. With consent of the other side, Mr. K. R. Barua, counsel for the petitioner, pays for adjournment. Prayer is allowed. List on? Okay. List on 4th of December.
For the concern of other side, which item number 26.
Item?
26.
26.
Reply has to be filed with me.
I'm waiting for petition, Lordship. Lordship, can you fix the matter on 2011, Lordship?
2011. You can file your affidavit by then?
Lordship, actually, my senior is already with the leave of absence, he's out of station. Lordship. Kindly, some 2 weeks time will be given.
This absence is from up to 17, Lordship. His absence is up to 17.
Give him some time. He'll come and then draft and he will make it 22nd then. 20 fix on 22/11 as prayed for by counsel for the petitioner. to enable him to, sorry, respondent to file affidavit in opposition. Okay. That is item number 26. Okay. 47. Okay. You're taking consent of the other side. Okay. With consent of the other side, counsel for the petitioner prays for adjournment. Prayer is allowed. List after 2 weeks. Okay.
Yeah.
27.
That is already withdrawn by the.
It has become infructuous. Okay. Also, the duly represented. Upon instruction, says Butthole, counsel for the petitioner has submitted that the order impugned in the writ petition has been withdrawn by the respondent authorities, and therefore he has instructions not to press the matter. Just accordingly, this writ petition stands closed, having not been pressed. Any interim order is operating? Okay, interim order stands, stands vacated.
Daily list item 1 for withdrawal.
Your name? Upon instructions, Mr. J. Bapan, counsel for the petition, pays for allowing to withdraw the writ petition. For government will be there, Mr. Bokalial, you will be there. Mr. G. Bokalial, government advocate is present. Matter stands dismissed on withdrawal. Item 2.
This year's online tender invited by investment amount is 27 crores 91 lakh, roughly 28. This tender has got two aspects. One is technical aspect, other is procedural. Kindly remove page 102 and 103.
Yes. Yes.
And subsequent to RTI information, it has been revealed that there are 21 that means small estimate. Some up to 1.25 lakh, 1.39 lakh this way, small road. In different places, not single place, this can reverse. In order to eliminate some small and smaller category tendering, respondent irrigation department has clubbed into a bigger. This pay 300 crores. This is one of the tender. 300 crores they made in 10 groups. And in violation of the certain provision of law of contract act, section 10, section 11, section 13, section 14, section. Can you give the RTN from the back?
Okay.
Now, this is not the one thing. Earlier also, two tender in the cases have been pending reports already. An order was already annexed in case 105. And few days back, Honorable Court of Mr. Justice Kumar Singh also issued notice to Education Department same tender. So my submission is that respondent irrigation department last to debar the certain class of categories of contractors and in the interest of the larger and bigger contractors, they made the 300 crores of amount of tender value in 10 groups. So 10 groups, and what the law of contract says? Law of contract says, page 10, they kindly produce at 11. What they say? Petitioner based refer section 16 undoing. What is 5 for kindly produce is for your proper ethics for you. There is also order of the Allahabad High Court, which I can give to this. What have you for their purpose is to eliminate the small category contractors and to happen of the big and bigger. So at least let this people to let this the appellate party to Then let's try to score what is the local, what they can, what the part of. In I just want section 10, section 11, section 10, 13 and 14. So therefore my submission is that it is in violation of certain specific provisions of law of contract act. So therefore, these standards should be stopped or this process should be stopped till disposal of the restriction. Because it is not proper that all the 300 crores will be distributed to same because in the interest of the somebody is influence some content. And there is a term given fiduciary relationship. Fiduciary relationship means the dictionary meaning that the people who is in power, who has been given the task of the people, that is the order dictionary. So my submission is that this court may kindly please to take proper action. At least my prayer is to stop the tender. Now finally this court will decide what is proper and what is not proper.
Okay. Heard. Mr. P.K. Bhattacharya, counsel for the, petitioner in person, and Mr. N. Upadhyay, Leonard, standing counsel for the irrigation department. The case of the petitioner is that he is a contractor of irrigation department. First off, it is presumed that the chief engineer, minor irrigation department, has issued a tender bearing NIT number 28 within bracket capital SMI bracket closed 2023-24 dated 11/10/2023, having a total value of 2791.69120 lakh pertaining to package number 1. First off, the case of the petitioner is that he had applied for information under RTI Act, and he has been informed in the RTI reply that the package includes about 21 groups having separate estimates for various items. First off, it is projected that the government, at the behest of large bigger contractors, have envisaged this device to curtail competition and to eliminate small bidders from participating in the bidding process. It is projected by the petitioner that in envisaging an IT to curtail competition, various provisions of the Contract Act, like section 10, 13, 14, have been violated. So it is submitted that in a similar it is submitted that in a similar circumstances, a coordinated bench of this court by order. Which page is that order?
105.
105. by an order dated 4/8/2023, passed in WPC 4185 of 2023, had issued a notice to examine the matter. Full stop. It is, while dictating, please don't interrupt. After I finish, then you may say anything. It is also submitted that in connection with a lack of consent or tainted consent, he is also relying on a judgment of the Allahabad High Court in the case of Deo Nandan, DEO, next word, Nandan, NANDAN, within bracket deceased by LRs versus Chote, CHHOTE, AIR 1983, Allahabad 9. Next paragraph. In the context of the preparation of a tender, it is the choice of the authorities who would frame the terms and conditions of the tender. Merely because a particular contract envisages various estimates would not be sufficient to presume that the government, at the behest of bigger contractors, have devised a means and ways to eliminate competition. Full stop. A comparative example can be had with regard to any construction of a building where several estimates are prepared. The PWD in the civil wing would prepare an estimate of the RCC construction, whereas PWD electrical would have a separate estimate for electrical items. So similarly, in respect of certain other items, it may be possible that other departments would also have their own estimate. For example, the authorities making the water connection may have their own estimates to be given. Therefore, merely because a contract envisages multiple components spread over a large area in the entire state of Assam, itself is not a sufficient ground for the court to substitute its wisdom on the nature of tender, which has been floated by the called by the authorities. The court has absolutely no expertise to make an assessment as to what would be the arena of or area of the contract, what would be the scope and nature, and the other modalities which are required for day-to-day management of the tender process. Next para. The coordinate bench of this court has issued a notice, but the issue has not been decided, and therefore the mere issuance of notice would not constitute a binding precedent for this court to issue a notice mechanically without being satisfied that there are materials to show that the government are in league with large contractors to devise this tender to eliminate competition. Next paragraph. Insofar as the decision of the Allahabad High Court in the case of Deonandan, DEO, NANDN, within bracket Supra is concerned, comma, the said the facts of the said case is that a sale deed relating to agricultural land, which was impugned by the plaintiff, was impugned by the plaintiff on the ground that it was fraudulent and that the deed was obtained by practicing fraud. And it is under the said circumstances that the Allahabad High Court had been called upon to examine the contract in the light of provisions of section 10, 13, and 14 of the Contract Act. The provisions of there's nothing contained in the provisions of section 10 13 and 14, which would go on to show that the tender, which is merely an offer made by the state for the contractors to participate in the or to make to participate and or make their bids, has become a contract between two parties within the meaning of the Contract Act, and so as to examine the tender in light of section 10, 13, and 14 of the Contract Act. Section 13 is the provision for relating to what agreements are contracts. Section 13 defines consent, and section 14 defines inverted within inverted commas free consent. Full stop. None of these three issues would arise in connection with offer inviting notice inviting tender. Full stop. Therefore, the court is of the considered opinion that the issues of tender has got no relevance insofar as section 10, 13, and 14 of the Contract Act is concerned. Next paragraph. It has been well settled that in the process of inviting tender, the scope of the state is within the realm of a contract, and therefore, in a commercial on commercially examining the viability of each contract, the state should have its own say in envisaging the scope of the tender and scope of the work. Full stop. Therefore, merely because a contract, a tender process envisages contract all over the state, work within the entire state, and may have different components in the estimate, in the considered opinion of the court, would not be sufficient for the court to start evaluating or examine the initiation of the tender process and to fish out the and to embark on a fact-finding yeah, fact-finding work as to whether the tender is proper or not. What would be the scope of the contract? Why a large contract should be split into multiple contracts, or why multiple contracts should not be clubbed and made a composite contract. So these are this comma in the opinion of the court is within the domain of the state and the authorities concerned. So therefore, court finds no reason to entertain this writ petition, and therefore this writ petition stands dismissed at the motion stage without issuance of notice on the respondents.
No, all right.
Now, yes, anything you want to say?
Already put it, I think this one.
All right.
Item 3. Yes. I find it difficult. The questions you are raising are very difficult questions. Number one, your shop was raised by fire. Correct. Now, if I understand the theme of Transfer of Property Act correctly, I may be wrong because I read alone without any assistance. I can give you TP Act, give her TP Act, Transfer of Property Act. You see, what my limited understanding of the Transfer of Property Act is that if a tenanted premises gets raised by fire, the land reverts back to the owner. Correct. So with that principle, I am saying I may be wrong because when I read it alone without any assistance, I may read it wrongly. That is number one. Number two, the authorities permitted others to make a construction. Now, that is one aspect. You were not given. But assuming that you construct premises on a barren land, then Section 5 of the Non-Agricultural Area Tenancy Act would apply, and therefore you would be you will not be evicted. No, that's okay. But now we are examining your case. Correct. So that is the arena of my difficulty, because if we permit you to make a construction, now you'll have to give an undertaking that you will not claim right under the let us say we ask you to give an undertaking not to claim right under the Section 5 of the Non-Agricultural Area Tenancy Act. Any agreement which is contrary to law would be void. So therefore we can't do that. Now, what is the way out? I'm issuing a notice, but this is something you'll have to examine. No, ordinarily, you see, what happens is that when you go for reconstruction, that's the third problem which I am facing. Ideally, when a tenanted premises is burned by fire, you would approach a civil court and get a civil decree to able to create your right to become a what you call to become a tenant. Now here, a right to construction would not be a what you call justiciable as a fundamental right. Your right to construct and have become a tenant is not a fundamental right. Therefore, it doesn't attract Part 3. And therefore, why would a writ court give you an what you call right to create a construction and become a tenant? Because you see, because for becoming a tenant, also it will be required that the municipality or that Gaon Panchayat, wherever your shop is, you'll have to enter into a tenancy agreement. Now, can a writ court compel someone to become a to make a tenancy agreement and then accept him as a tenant? This is again something which I don't know. I have my own reservations, but I'm issuing a notice. Mr. Paglia, take care of it. It's okay. I'm issuing a notice. I'm not dismissing it right now, but these are the three issues. There is a possibility of dismissing the writ petition in the motion stage also. But since you say that others were permitted, you are not. We are issuing a notice at this stage. Mrs. R. Chaudhary, counsel for the petitioner. and Mr. G. Bakalia, government advocate, appearing for the respondent numbers 1 and 2. By filing this writ petition under Article 226 of the Constitution of India, the petitioner projects that the shop premises of the petitioner, which was under the Tejpur Municipal Board, within bracket respondent number 3, was burned by fire. And while others were permitted to make construction, the petitioner was not permitted to make the construction, purportedly because of pendency of a civil suit, which is now pending before this court in second appeal. Or second appeal disposal. So pendency of a civil suit, which has since been arising, out of which a second appeal has been disposed of. Full stop. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the government advocate. Petitioner shall take steps within 2 days for service of notice on respondent number 3 by registered post with AD, as well as by way of Dasti, by routing the process to the registry of the court, and upon service and affidavit of service. The pendency of the writ petition shall not be a bar for the authorities of the Tejpur Municipal Board within bracket respondent number 3 to examine the grievance of the petitioner.
Item
Four.
4.
Unpaid contractual dues. Mr. R.K. Agarwal, counsel for the petitioner. Mr. S. Bora, standing counsel for all the respondents. Both the respondents. And notice steps, extra copies, steps. Extra copies. Pendency shall not be a bar for the respondent authorities to examine the claim of the petitioner and to make payment if found due.
Right.
Item 5. This is also contractual dues, same author, Mr. I. Chaudhary, senior counsel, assisted by Mr. H. Buragoni, counsel for the petitioner.
For the respondent, one
Mr. S. S. Roy, CEC for respondent number
8. Sorry, 8.
8.
Yeah. For the rest notice.
For rest notice has to go. Extra copies for respondent 8. Steps for 1 to 7. Pendency shall not be a bar. But here also I have a question. I am issuing a notice. But the fact is that the payment due is by the company. But whether
Actually, the contract was awarded by a government of India already. My individual contract is with them, not
with the government, not with this company.
not with this.
Okay, okay. Then it's okay. Okay.
5.
This is 5.
Same.
5 and 6 same.
5 and 6 same. Okay.
Same.
7. Contract labor. I'm showing a notice here. Mr. S. B. Laskar, counsel for the petitioner, and Mr. B. Chaudhary, learned standing counsel for the APTCL. You are appearing for all?
2, 3, 5, and 6.
2, 3, 5, and 6. Would be for others?
For respondent number 1, what are the states of here? Power department.
One is power. Mr. K. Gogoi is senior government advocate for respondent number. Additional senior government advocate for respondent number 1.
7.
Finance, Mr. H. Alia, standing counsel for finance, represent respondent number 4.
7 is the members of private contractors.
Okay. Next, the petitioner projects himself to be the daily wage Sahayak of Nilchera, NILCHERRA under respondent number 6 engaged through respondent numbers, private respondent number 7. So it is claimed that the petitioner has not been given the benefit of enhanced wages oblique pay in accordance with principle of equal work, equal pay. And that the respondent authorities have not, sorry, the APDCL authorities have not taken any decision as per minutes dated 12/8/2022. Hence this writ petition under Article 226 of the Constitution of India. Notice requisite extra copies to the State and Departmental Council. Steps within 2 days for service of notice on respondent number 7 by registered post with AD. Now this will never be served. Respondent number 7. You are working under them, you don't know their address. No, you see the government officer, he will not go around move to serve notice on your behalf. But then it would be very easy. X, he's a peon in the office of so and so, care of chief secretary. Now chief secretary will receive this notice, find out this peon and make service. So the chief secretary is no longer be in the office. He'll be moving around the entire state, serving notices one after other. This is something I personally do not want. You say that you are a contractor under them. You are a labor under this. You say that your engagement is through this RV. No, whoever is done, but now you are getting salary through them. And you don't know the address of the employer. No, this is something which is not permissible. Huh? No, you have to give the address. Next para. It is seen that the address of respondent number 7 is care of the SDE, Kaline Electrical Subdivision. Most of the court does not appreciate the service, routed service when the respondent number 7 is the employer of the petitioner. So therefore, in order to have notice issued on respondent number 7, the petitioner shall provide the correct postal address of the respondent number 7 to be incorporated in the cost title. And on providing of the correct and complete postal address of respondent number 7, notice would be issued on respondent number 7 by registered post with AD. So the land council for the petitioner is permitted 7 days time to collect the correct postal address and provide correct postal address in the cost title, which shall and the necessary corrections shall be done in the section, civil rule section. Civil rule section. Civil rule pending. Extra copies. Notice is made within 4 weeks. The pendency of the petition shall not be a bar for the respondent authorities in the APDCL to examine the claim of the petitioner regarding non-implementation of the minutes dated 12/8/2022.
showing the name of CA in the cost list.
Oh, you are also appearing for, oh, for part one, yes, the registration reflect the name of G Assam, the cause list for respondent number 1. For listing the matter next. Okay. Item 8. E-rickshaw, I'll issue a notice here.
Lordship. Well,
No, we are issuing notice. You have any objection? Objection, yes, okay. Here's objection. We'll adjourn the matter. You see, so far as I understand, to be a good lawyer, when any presiding officer of any court speaks this much, if he speaks, you must understand this much. That is my thumb rule. After some time. Item 55.
applied.
Yes. Oh, yes.
Yes, my lord. My lord, kindly peruse Annexure 7, page 29. When he was granted permission, the earlier permission,
Yes.
dated 24/8/2020. I have to invite reference to the above subject and state that Dr. Tawajuddin Ahmed, that is the petitioner, may be performed ultrasonography at Dr. Sarkar's polyclinic, Hatsingimari, Dhubri, as he possessed a postgraduate qualification in sonography from the Global Open University, Nagaland, recognized by IMA AMS for 2 years, subject to qualifying competency-based test under the 6 months training rules. So that was a condition, my lord. Now, my lord, that condition he has not fulfilled. And accordingly, my lord, the impugned order has been passed at page 32, my lord. Page 32, my lord. The
No, just a moment. Let me have this act.
I have a copy of that.
Please show me that. It is just like our bar exams.
Yes.
You get a degree and then you have to clear the bar exams. Only then you can practice.
No, he has to undergo a 6 months training course under this act, my lord, under the.
Hey, so that's
It has been amended also. Rule 6, my lord, Rule 6 is relevant, my lord. And it has been subsequently amended, my lord. Six has been amended, my lord, by the. The rule itself is called PCPNDT, Prohibition of Sex 6 months training rules. 2014.
now it's in rule 6 for sub-rule 2. Following sub-rule shall be substituted. 6.2. Registered who are conducting so and so 1 year experience 6 months training exempted. Oh, so he doesn't have that.
And the impugned order, my lord, that is at page 32, my lord. It has been specifically mentioned that point, my lord. The down below, my lord. In view of above observation, you are hereby requested to take action within very short time on the following points. Number one is you should take steps for setting up separate setups in relation to name care, medical and diagnostic center immediately. Because first point was that because he has set up the ultrasonography clinic inside that clinic, my lord. So he was asked to make a different setup. So number 2 point is you should apply to the
No, but a
DS.
hospital must have a unit.
No, my lord, because for that specific permission is required, my lord.
Okay.
Because that is a clinical establishment, and for that purpose, the specific permission under the.
Please don't disturb. No point when I'm asking him. I'll come to you because you yourself said that the notice instructions were required. Correct. So you yourself said that, and so now I'm asking him, then you are trying to interrupt. Don't do it. Because when I'm speaking to him, these gestures attract my attention. No, don't do it.
And second point, my lord, you should apply to the DSS FW Assam for renewal of your permission to do USG. For reference, a copy of such letter by so and so that.
No, but every hospital does not doesn't have a establishment for.
It is not a hospital, my lord. It is a clinic, my lord. Clinical establishment. For the clinical establishment part, my lord, there are separate permission under the from the joint director is required, my lord.
Clinic means it's not a hospital. It's just a clinical establishment.
It is not a hospital.
Okay, okay.
It is not a hospital. So number 2 point is that you should apply to the DSS FW Assam for renewal of your permission to do ultrasound. And
Okay.
because while granting permission that I have referred to your lordship at page 29, my lord, there it has been stipulated that it has been granted subject to the condition that the petitioner qualifying for competency-based test under the 6 months training.
Okay, I'll just hear him and then come back to you.
Yes, madam.
Yes.
My lord. Kindly see, page 29. For my language.
Yes, we are there.
Page 29, last para, point number 3. If a medical practitioner takes the same confidential determination of the clinic attendance, he shall undertake the complete 6 months training as provided under the rules for the purpose of renewal of the registration. 3 attempts, not 1 attempt. Only one time during the course of coronavirus, the year 2021, examination was held. In the year 2022 and 2023, no examination was held. And in the year 2021, for the personal difficulties, petitioner was not able to appear the examination. 2 times already been required. Petitioner has already 2 years course at the Global University, Sonologist, Nagaland Global University. Kindly lordship, see the definition clause of this sonologist. Section 2, clause P of the Parents Act 1994.
Which act?
PCPNDP Act.
PC means this.
Preconception and prenatal diagnosis.
Oh, acha, okay. Pre
Preconception.
conception,
and
preconception,
Prenatal.
Diagnostic techniques.
preconception.
Provincial Secretary. 1992. Amended by
Which provision?
definition clause, section 2. Section 2, clause P.
Yes.
Sonologist or medical specialist means a person who possesses any one of the Act 1956. Who possesses any one, possesses the medical qualification recognized under the Indian Medical Council in 1956. Petitioner is MBBS, recognized under Medical Council in 1956. Second, or who possesses a postgraduate qualification in ultrasonography. Petitioner already has postgraduate qualification in ultrasonography or imaging techniques or radiology. Even then, my lord, only in the year 2021 examination was held.
Sonologist does not have an MBBS degree.
Obviously.
Huh.
Here, my lord, any medical practitioner recognized under the Indian Medical Council Act 1956 is recognized that is MBBS degree.
Okay.
Or who possesses a postgraduate qualification in ultrasonography. Both the degree he has. Thereafter, even in accordance with the rule, 3 attempts, not 1 attempt. In the year 2021, examination was held, but did not appear due to personal difficulty. Till today, no examination was held. How this question will arise right now? Apart from this, my lord, kindly see section 20 of the statement.
Yes.
Section 20 of the statement. Cancellation or suspension of registration. Notice has to be given. Reasonable opportunity has to be heard. Has to be given. Yes, section 3. Without notice, appropriate authority may cancel the registration admission. Order should be given. I will kindly go through the previous order. As passed by Justice Huzur, kindly see that. It's not reasonable. Yeah, look at authority seated. The MPR and order passed against me.
Just a minute. But then we'll have to extend the stay. We'll issue notice and extend the stay. There are two reasons for that. Number one, that the one of the ground is that what do you call, he'll have to apply for extension of permission, renewal. So that is something which which can always be done. That's number one. Now, taking steps for separating setup, that I think you have given the permission.
Yes, my lord, but he has not, because inside that name care.
Please don't interrupt. This is the second time I'm telling you. When I'm asking him a question, please don't interrupt.
He has set up his ultrasound clinic.
I'm not always so polite. Correct? Yes.
My lord, he has, because as per this impugn the letter, my lord, he has set up the ultrasound clinic inside the name care medical and diagnostic center. And as per the permission at page 22, my lord, I have to know that you have been given permission to shift your USG clinic, namely Life and Show, to Jhagrapar, part 1 under Hubli district. So he has to set up a separate clinic, but not inside that clinic, my lord.
Okay.
Because, my lord, to run a clinic, my lord, the permission under the Clinical Establishment Act is required. That is given by the joint director, concerned joint director. But for ultrasound, my lord, under this specific acts and rules, my lord, the provisions are there.
Does it bar in a clinical establishment?
Yes, my lord.
Which provision?
My lord, in terms of the impugn order, may I submit one thing, my lord? Because here in the point number 2, it has been stated that you should apply to the DSS FW Assam for renewal. So, my lord, let him apply to the concerned authority, my lord, and the authority may take a decision, my lord, followed by issuing a speaking order. Until then, my lord, he may be allowed to continue, my lord.
Yes.
Kindly see, impugn order 32.
Yes.
First, subject regarding reply on alleged gross malpractices in your university clinic. This is the subject. Kindly see first point, one diagnostic clinic, namely Nemcare Medical Diagnostic Center, is functioning along with your university center. Number 2, kindly see.
No, you complete one part. When you are reading number 1, you complete that part. You are to set up in Nemcare or you are to set up in separate.
Nemcare is different entity, different proprietor. I don't concern about Nemcare. This is separate entity.
So you are concerned with whom?
I'm concerned Lifeline. I'm the proprietor of Lifeline.
Where is it located?
Inside the name care.
Where is it located?
Located at Koblar Park, Buguri, part 1. And Nemcare is different. Second point, can you?
No, you see, we understand in the terms of Guwahati. You see, if somebody says that he is in Fancy Bazaar would be a large area. Somebody says he is in Dispur would be a large area. Now this Jhograr par, I don't know what is the size. No, I don't know, but this the address which you have given in the cost title at page 4. This is not the address where you are running the this diagnostic center. Look at your page 4. What address you have given? Is it functioning there?
Page 4. Not there, not there.
Not there.
This is
So
the address of the petitioner. And clinic address is Dhubri, Green Town, Joglar Park, Part 1.
okay.
They are the Dhubri
And this
medical college.
and this name care medical you are not there.
They are, but this is not mine. This is different clinic.
No. You see, please, you please read this. One diagnostic clinic, namely Nemcare Medical and Diagnostic Center, is functioning along with your USG center.
Yes,
Is it right or wrong?
it's wrong. Not along with. My lord, kindly, next second point you did, kindly.
Yes.
One, your diagnosis center was found closed during our visit and no patient was found there. If it was closed, now the authority had seen that another clinic is functioning along with my clinic.
Don't tell those things. It doesn't take you anywhere. You go to shop X and you find it is closed. Why shop Y next door is functioning? And it is recorded that. Those arguments won't take you anywhere.
So I am like my lord, I am the proprietor of life. Name care, I don't know.
Okay. This. So we'll record that statement.
Yes, my lord.
If
And
it's-
secondly, my submission is that, my lord, in terms of point 2, my lord, he may apply for renewal to the.
That's okay, but if the council is making a statement that he is not in name care,
Yes, my lord.
we'll record that statement.
He is saying that it is not, but
He's-
our stand is that it is within the, inside the name here, my lord.
It's okay, we'll record that statement.
Yes, my lord.
Heard Mr. ATM Hussain, counsel for the petitioner, and Mr. DP Boral, and standing counsel for the health department. Appearing for all the respondents?
Yes, my lord.
Appearing for all the respondents.
Except 5, my lord.
For respondent was 1 to 4.
Yes.
And Mr. G. Bokarial and a government advocate appearing for respondent number 5.
Right.
Next paragraph. Referring to the impugned notice dated 39/2023 within bracket annexure 8, numerical 8, bracket close, comma, the learned counsel for the petitioner has submitted that the petitioner is operating a sonography center in the name of Life, next word line, Sonography Center at Jhograr Par, JHAGRARPAR, Dhubri. He has specifically submitted that his center is not within Nemcare Medical and Diagnostic Center, which is a separate entity. Full stop. Is further submitted that the petitioner got permission to operate the sonography center by a communication dated 29/6/2022 issued by the Where is your center? Which was the document you showed for your permission? This page 29.
Yes.
Right.
Director,
Communication dated 24/8/2020 issued by the Director of Health Services within bracket FW bracket close Assam. Come state appropriate authority under PC-TN-DT Act. This page 30, huh? This name. So it is submitted that the requirement of law is the law is that the petitioner would have to appear in clear test within three for which he gets 3 opportunities. First, it is submitted that from the date of such permission, comma, he could not appear in one test conducted in the year 2020, and that since 2020, no further test public exam has been conducted by the health authorities, and therefore the petitioner has not availed 3 opportunities to clear the exams. Hence, it is submitted that the petitioner is not required to undergo 6 months compulsory training. Full stop. He has submitted that as far as the prayer for renewal is concerned, the petitioner is ready and willing to apply for a renewal of the license of the said sonography center. Next paragraph. Per contract or pursuant to order dated 10/11/2023, the Learned Standing Counsel for the Health Department has submitted that the petitioner has not been able to show that he has cleared the test so as to make him eligible for exemption of 6 months compulsory training. Are you aware of the training held, this examination held or not? No. So how he has submitted that he is not instructed of Toyota. That how many tests were, how many exams were conducted after the year after August 2020? No, he does not know that. I'm not putting words which he has not said. So how he submits that he does not oppose the submission or the Learned Counsel for the he does not oppose the petitioner applying for extension renewal of his license. Next paragraph. You should notice a motion returnable info. You want a shorter date?
Yes, madam.
How much?
Under 2 weeks.
Returnable in 2 weeks. Requisite extra copies of the petition we served on the Learned Standing Counsel for the State and Departmental Counsel in course of the day. Next paragraph. Taking note of the submissions made by Learned Counsel for the petitioner that is the clinical establishment of the petitioner is not within the precinct, PRECINT precinct of Namecare Medical and Diagnostic Center, which is functioning separately. Namecare Medical and Diagnostic Center, separately, comma, as an interim measure until the next returnable date. The interim order passed on 10/11/2023 stands extended. Next paragraph, list after 4 weeks. The petitioner shall produce a certified copy of this order before the whom?
Director of Health Services within bracket appropriate.
Acha, Director of Health Services, his respondent number.
That's the number.
Respondent 3, to bring the order to the notice of the said authority. Returning you your gazette notification.
In the meantime, let him apply for a renewal and the authority will consider my lord.
Just you say that, huh? In the meanwhile, the petitioner shall apply for renewal of the clinical establishment of the petitioner.
And the
For
authority
renewal.
may consider
No,
the.
I'm not saying that.
But we can agree.
56. Dr. Saraf, this I've seen that under Rule 86A, the CGST empowers the commissioner to take ex parte action.
In the book from district. You are also distributed the given. Because submitted it was I also put in the portal. The printouts. The input of credit which was available. One on the president which was made for the members. Input of credit can be available only when the amount is relocated in the nature. Now I sold the goods, the same goods to outside that I also maintained. I got issued with a summons, input from Catering. And I was asked to produce all the papers in different respect of strategic and sales. I produced all the papers, including the checks, invoices, which is, and the MVP invoice, which was generated by the portal, all were there produced. Now suddenly, in 2003, I received a order working my calculation,
Yes.
and that has been saved out the 3 grounds. That the parties are non-existent. Now, today in 2023, it will be non-existent, how we will change the registration. But that will not affect on the period when we have the transition of the SURE restricted. And he has submitted the returns. So one ground is mentioning that they are not non-existent. Second,
But these things are matter which can be handled in the post what you call the post hearing. What is it? What is the term used? Post decisional hearing. Yes.
and take action if it's taken without issuing a so-called notice, without taking action, because
No, that's why I was searching for that answer, and I found 86A.
as part the action, but 26, 21, when you issue a summons,
21. Just give it the GST Act. GST Act. Volume 1, GST manual. GST manual. Volume 1.
any action will not, which is taken, which is responsible. There must be a violation, not be a violation, which is justice. I must be informed on what basis you are taking action.
No, that's you are absolutely right. But then that's the answer is 86A, because that is something I found in 86A.
Wherever the problems are, not there, there are the mistakes. It has to be ready. Ex parte doesn't mean that without doing anything and you can do it whatever you want to do. That cannot be.
I don't know, you'll have to convince me. I'm not saying, I'm not making any comment, but this is what you see, the difficulty is when I read alone. I've got no assistance, so therefore whatever whatever goes into the head, it's okay. What doesn't go is again okay. Yes, this is Rule 86A. Rule 86A of CGST. Finding this is very difficult in this book.
Yes, the text man knows it, but it is not arranged as per section.
Huh. 6 point so and so, 1.5 so and so, very difficult to find in this. But nonetheless, we'll issue a notice in this matter. 86A, Commissioner authorized by him on this behalf not below the rank of Assistant Commissioner reason to believe that credit input is available in the
We don't have. When by the electoral ledger has been fraudulently availed.
Huh.
Or ineligible, in as much as, first of all, it must be fraudulently availed. Can you also see
A1 is issued by a registered person who is found non-existing.
a non-existing? Now, if the person was existing on the records itself, the person, I've given the the registration, the portal or details, they submitted the returns, he was existing. So it cannot be said that he was not existing at all. Now, secondly, you also see, it says that issued by registered dealer person who has been found non-existent or not conducting any business. You yourself are registered, he issued the tax invoice. And he had also issued the challenge, which is generated from the portal. You cannot issue the challenge himself. It has to be generated from the portal only. So that was generated from the portal. How it can be said that he was not conducting the business?
No, non-existing is something else. Non-existing is something, since I come from a place where many things happen, this, what you call, because you see, Dr. Saraf, this is something I'm addressing the bar, not only you, I'm addressing to the bar. You see, we are in difficulty. People ask us, why you don't socialize? And this is a question asked by many persons of many variety. Now, what I think in this, when this question is asked, is that I may know X. He's a personal friend, I know X, but I do not know the name of the firm in which he does business. And therefore, what happens is that tomorrow X, you may accuse that I was yesterday standing with X and litigation of X I have handled today. Well, I have absolutely no idea who this X is. And supposing what happens is that, let us say, for example, a very known company is Tata Holdings. We all know of Tata Holdings. Tata Holdings may have hundreds of business where they may use the name of Tata, may not use the name of that symbol. And therefore, what litigation is coming to the court, we don't know. And therefore, we may be accused of hobnobbing with litigants. No, what I'm trying to tell you is that the point which I'm making is that I may know that A is doing business in the name of A company, but I am not aware that he is doing name in the business of B company, C company, D company. And now those firms, 3 firms, may be non-existing companies, because it is the main facade which we are looking at. It is A company, but B, C, D are subsidiaries or those companies which don't have actual existence.
When you say that same companies are there, this is not the case of that.
Okay.
The person concerned is one. The person concerned, the 3 firms are the different firms. They are all registered. They submitted the returns. They generated the e-challan from the portal. They raised the tax invoices. The tax in the input tax rate was there on the portal. Now, that if I say that was non-existent means what? That it was not there at all. When your department sends the registration, when the department gives the invoices, when the goods are supplied and I make the payment, and what I have done now, ultimately what the department has got the full tax. Because I have taken the input tax credit and whereas I have given. So there is no purchase at all. And you also can see 86A is not an arbitrary power. It is held by certain conditions. These conditions must be fulfilled. Now, if these conditions are being fulfilled, the order which you also be saying, see, it seems one line only that the fund is non-existent. Whereas your Lordship is the first word, it is that fraudulently. Your Lordship first is the fraudulently. Now, the condition, subsequent condition is stated by the condition of fraudulently. For that, he must have reason to believe. Now, once the reason to believe and fraudulently, that must be passed by an order. Thereafter, you can pass an order. I don't say that you cannot pass the order.
No, but this is not a proceeding where this reasons to believe what you call those audit provision or
Your Lordship,
this, huh.
Your Lordship, but the reason to believe fraudulently, what fraudulently was
No, we are issuing a notice. In fact,
my entire business will stop. Because the credit ledger is blocked. Whatever I purchase, that will not come into the credit ledger. Neither I can use the credit, the input tax credit. Leave aside the 3%. Leaving aside the 3%. I carry on the business. From other persons I am purchasing. I am paying the taxes. It will not come to input tax credit, the credit ledger at all. The amount of the tax which I pay.
yes, but Mr. Kyal, Dr. Saraf has raised a valid point. If you accept a registration of a firm and I go and purchase it from there, or any businessman purchases it from there, shows it the input credit, all those are created from the what you call, from the portal of the GST. Now, if it is fake, why should somebody else suffer for that?
Please to see my written instruction.
I've seen that. I've seen that.
They are credited as a stock for the amount for 74 lakhs and other, not for entire amount. So that is also clarified in the my written instruction.
Pardon me?
Their credit ledger is been blocked for the amount of 74 lakhs. They have written, this is not their entitled. If the my credit ledger is working now, please to see my instruction.
No, just tell me, because it's very difficult to understand. It doesn't say part.
Amount has been mentioned as true.
Action was initiated blocking of the electronic credit ledger by an amount equivalent to 7981. So beyond that, if he has any money in that ledger, it can be permitted.
That is expected from the written instruction.
Show it to Dr. Saraf.
The credit ledger is at present operational.
Yes, he's saying that.
So let him submit it.
No, that's what he's saying. He's given a. So it is only blocked for the amount of 70, the disputed amount of 78. But but in the meantime, you will get a post decisional hearing. So in fact, we'll say that.
Only middle of this month it has come. So Lordship is para 8. Exactly the same issue.
No, correct, you are right. But for the time being, we can't give you the entire relief. We'll just say that. Yes.
You also may ask him to provide the affidavit and the police report. In the meantime, I tell you, accept this one, serve yours.
Yes, we will provide that. He's not objecting to that. But in GST matters, reading alone without any assistance is very difficult. No, not that. No, the knowledge of business and knowledge of GST. No, not that. Since it's a new subject. No, you are extremely seasoned, but no, when you say you are being very humble, but we know you are an authority in tax. But but for us, jumping from
In the meantime, Proxy may take note of the one of the judgment of Allahabad High Court, of the division bench. Proxy will report it in.
No, it's okay. Where you make your submissions then. It's just a preliminary idea I'm just trying to have because these things don't come very often. So therefore, I'm just trying to understand.
Provided for. And then also hearing has to be given.
Yes.
21, the summon one issue, I'm not aware of it. Suddenly you block it.
No, you have a point. This is what I was urging. This Allahabad High Court has dealt with this because you see, what is the fault in a purchase going and purchasing it from a shop? Say, let us say in the very neighborhood, there's some shop. He has displayed in the signboard a GSTN number. Correct. You go to the shop, purchase something, come back. Now, mandatorily you are required to show something in your returns. So when you purchase something, let us say some item where you have to disclose it, you disclose that. And then people say that it's a fake, and then the punishment is to the purchaser.
This first example, as in this, I give a first example. Person purchasing. I'm not aware from him where he getting the goods. I cannot be aware where from he getting the goods. Now I purchase him, he gives me tax invoices, he gives me goods. Now you say that no, he in fact where from he purchase not there. How I know I got the goods? You take care of him. You take care of him that where from he got it and all those things. But so far I am concerned. When I received the goods, when I got the tax invoices, he sold the goods. How you can say that no?
You have a point. You have a valid point. I agree with you.
This is the law as on date law.
No, that's okay. But you see, constitutionally, we take an oath under Form 3. You are aware of it. The form, you are aware when we take oath. And it says that I shall uphold the Constitution and the laws. Correct. But are we bound to do it? If I find a provision of a Constitution, ultra vires, we strike down the provision of Constitution, we strike down the provisions of the law. So therefore, in essence, what we are doing is that we are upholding the basic structure of the Constitution, and therefore, whatever is not beyond it, we strike it down. So therefore, you see the Hippocratic oath of upholding the Constitution, the laws, is followed to the extent
Unless
it is not ultra vires to the Constitution.
Yes, law something possible.
No, that's okay.
And that,
That's
interestingly, that provision is upheld in different judgment. That provision under section 16(2), although this is some. 62, where from it coming? No, that's it. I'm just taking another. That provision has been challenged, but different high courts uphold the validity of that particular provision. Where the IPC was upheld by the purchaser. Seller. Purchaser has not paid the tax. And we have issued notice to the. I'm sorry, not by anything.
no, you see, I have still got reservations there. The problem is that you are burdening what you call the person who is what do we say? He's a soft target. People.
Now, that is not.
No, you see, laws are so. I'll tell you my personal example. Please switch on the video of the video. Per contra, comma, the learned standing counsel for the respondents has submitted that the entities with which the petitioner had transacted business were found non-existing and non-functional at their declared business premises. And the 4 steps are being, and that the tax invoices and e-way bills were raised by such fake entities. And that on being found fake, comma, the cancellation of GST registration of those entities have been initiated. It is also submitted that the petitioner's proprietor has been examined under the provisions of Section 70 of the CGST Act, 2017. And accordingly, action was initiated in terms of Rule 86, capital A, within bracket numerical 1, within bracket small a, within bracket Roman 1, small, of the CGST rules 2017. So, however, it is submitted that the blocking of the debit of the electronic credit register is only for an amount equivalent to rupees 79,81,424 on a specific query of the court, the learned standing counsel for the respondents has submitted that any transaction for an amount except rupees 79,81,424 would be permissible in the electronic credit ledger of the petitioner. Next para, issue notice returnable in 4 weeks. Requisite extra copies of the petition will be served on the learned departmental counsel in course of the day. Today or tomorrow, course of the day. Next para. In view of the specific query of the court and the stand taken by the learned standing counsel for the GST, as an interim measure, it is provided that except for for the blocked amount of rupees 79,81,424 standing in the electronic credit ledger of the petitioner, the respondent authorities would permit other transactions in the said credit ledger, electronic credit ledger of the petitioner. The petitioner shall serve a certified copy of this order to the to whom? To the respondent 3 to bring the notice to the notice of the order to the GST authorities. Yes. No, for that without a post decision hearing, they can't do it. No, they will not take it because post decision hearing is you please communicate.
Yes.
Post decision hearing is a must. No, not that. But Dr. Sir, what I have understood is that without a post decisional hearing, that is a step which they can't take. No, they will not do it. Please communicate. Please communicate. No. Coercive steps they can't be taken.
I understand,
Huh.
Communication, my understand also knows many communications have been made, but there are the orders have come.
Just make a just will say the petitioner, the senior counsel for the petitioner is permitted to move this court if any coercive steps taken against the petitioner. Make a mention for out of turn listing.
$57.
Yes. Again, this is something which is outside our scope. Just a moment. You are saying that there was a demarcation between the manufacturers and suppliers, and now that has been done away.
Earlier, the original IP where the contractual policy. Now, by virtue of the collision, they have been ousted from the.
Yes. No, not ousted. Now you are treated equally at par. So you're not getting an advantage which you had earlier.
I am the manufacturer. I am not following their present. I am not doing it. So initially, there are three categories which can participate. Manufacturer, the authorized dealer or distributor, and for an export. Now, the requirement that has been imposed by the collision is that I have to have the experience of sales.
Experience of
Sales.
sales.
Now, my agent.
No, definitely. You see, when you are manufacturing, you will be selling it.
Of course.
You don't manufacture to store it.
Applying the government or PSUs, that is the requirement that is there. And there is no actual reason why this particular cost would come, only because of liberty manufacturers.
Yes.
That is the first piece.
Lordship, I will take instruction, Lordship may take it upon Friday or Saturday since it's a working day on Saturday.
Friday.
Saturday, let it be.
No, not Saturday, Friday.
It's a working day.
The last date of submission is by the 20th. 20th of November is the last date of submission. They have
Monday.
or tender, we have extended it.
20. No, we'll take it up on Friday. Heard. Mr. M. K. Chaudhary, Senior Counsel, assisted by Mr. M. Sharma, Counsel for the petitioner, and full stop. Next para. On the prayer made by Mr. V. Chaudhary, learned, you are appearing as
Standing counsel, agriculture department.
as standing counsel for the Agriculture Department. Time is granted to enable him to obtain instructions on the point that why the manufacturer is required to have experience of selling its product to the government departments and PSUs. And the purpose ought to be achieved by that. List on 17/11/2023.
What's the extra copy?
Please give me an extra copy. This next item is
Similar. Lordship.
similar. Next item is okay. 57 and 58.
Yes.
Two items. 59 also, 3 items. Same order. Pass separately. I'll take a break and come back.
1991 Supreme Court.
I just had to provoke you. But Mr. Chaudhary, it's not an adverse comment to the members of the bar, but I think this page of yours must be adopted by more counsel, because of the fact that the readiness to recollect the provision and related to the what you call some case laws is really praiseworthy, and I think in fact the bar should have a small discourse for young members of the bar with people like you, Mr. Das, is sitting here to share your expertise with the members of the bar.
That's a good friend, my lord.
Huh?
We can share our experience, nothing beyond that.
Nothing beyond that is for the people to take up. Ms. Bhuya, this is contract I'm giving to you. 14 is in the previous page, D, contract determinable in nature. This is one.
There's our High Court judgment on this point, my lord.
I've also said,
That star cable, I appeared, my lord. Justice Gogoi authored the judgment.
okay, but
Relying
this is
on
something
that
I've
matter
also
of research,
I've
yes.
also dealt with this issue, contract being determinable in nature. 14D. And there's a second issue that when there's also already a termination, and this is
Injunction cannot be done.
no, this is a what you call contract for providing of service. Providing of service is again what you call contract for personal service is also covered by 14.
Lordship, may I bring you, Lordship, my landes's submission that they have not. They
I'll
have
give you
not-
10 days time.
Yes.
We'll give you 10 days time. In the meantime, they let you all three have.
Let the matter be listed
Ah.
after 10 days, let them approach, I'll also.
In the
put
meantime,
in
I'm
a
issuing a
open
notice so that we go one step ahead.
And they are not issuing, reissuing that.
That I don't think it will be fair on my part to.
matter. Put in a word.
It will not be fair on part of the court to record this statement and bind these people, but I think you'll communicate.
Yes,
Ah.
I'll definitely communicate.
We'll take it. Something we'll have to accept the face value. And when Mr. Chaudhary is saying it, he'll do it, but I don't want to bind the institution through his mouth. It leads to certain complications. Because this, when it comes to labor unrest, as he's referring to, many things will start playing.
It's better to avoid all this.
Lordship. That's why I could not take a position.
It's okay, I understand. That's why I said mediation. Although it's,
The industrial scene in West Bengal deteriorated only for this.
you are absolutely right.
My lawyer friend will agree, man.
It's not a
Otherwise,
question
one
of
of the
agreeing.
most-
No, it's not a question of agreeing. You see, we have created a factor where they become a major stakeholder. Then that
Correct.
causes the problem. You see, I don't understand few laws, but it's my limitation. Number one, you see, this is time tested. This is time tested. It's not only my experience, but I'm telling you, we have a tendency of not employing very qualified people in a private institution to man posts of, say, salesman or post of manager or a cashier in a private firm. That is something which comes with my upbringing in the community. You see, let us say that you engage a highly qualified person as your driver. I'm just giving an example. I'm not demeaning anyone. I'm just giving an example. My examples are always horrible, but it's only an example. Now, will you be happy with by engaging a highly qualified person as a driver? Will you have a confidence that he will work as per your dictates?
Yes. These are
Those-
things which needs to be pondered. That's very correct.
So therefore, these are limitations which I don't understand. You see, highly qualified, then this is one factor. The second is what you call with all this breakup of caste system and creed system. Now, if those factors come into play for a government, then why not those should be implemented in the private sector as well? Why in the why for engagement of what you call registration of lawyers in the bar council? We can't say that no, it will be proportionate representation of community wise. Now he is from X community, he will not be admitted for 2 years.
Correct.
These are many things. If you can do it in medical, you restrain the admission. Then you have this caste system of people coming in the what do you call as engineers and doctors. You are curtailing it at the root. Why not for a lawyer? MBBS you have LLB you have restriction of caste system, caste base. I don't understand few laws, but it's my limitation of understanding. So that's why please tolerate for some time. Heard Ms. B. Bhuya, Senior Counsel, assisted by Mr. A. Atriya, Counsel for the petitioner. Also heard Mr. K. Chaudhary, Senior Counsel, assisted by Ms. R. Kakoti, Counsel for the respondent numbers 1 to 4. And
Appear on the earlier matter.
No, 1 to 5, madam.
1 to 5.
One.
Okay, 1 to 5. Mr. You're not in this case, huh?
This is the
Okay.
other matter.
No, the other matter is this 3804.
I've been included.
So instead of two orders, I think I'll pass a common order.
Yes.
So and so for the petitioner, for the petitioner in WPC 6596 of 2023, and Mr. Ken Chaudhary, Senior Counsel, assisted by Sweden. Also heard Mr. A. Das Gupta, Senior Counsel, assisted by Ms. M. Das, Counsel for the private respondent in WPC 3804 of 2023. Next para the action of the respondent authorities in issuing termination letter dated 6/11/2023 is assailed in this writ petition filed under Article 226 of the Constitution of India. Next para, the learned counsel for the senior counsel for the petitioner has submitted that despite order dated 28/6/2023 passed in WPC 3804 of 2023, the petitioner has not been able to take over the entire kitchen site so as to provide catering service, catering and connected service to the Bongaigaon guest house and office complex of IOCL Bongaigaon.
At Guwahati.
Huh?
At Guwahati. It is a
Acha, Guwahati.
6 mile Guwahati.
Acha, Guwahati. Okay, Guwahati. Bongaigaon guest house and office here.
No, my love. Here is basically a guest house and there is some office staff also. This is basically a catering service. Catering.
No, you see, I'm just looking at the synopsis. In the synopsis, it is stated a service at Indian Oil Corporation Limited, Bongaigaon Guest House.
Oh, no. It is Guwahati, madam.
Guwahati.
No, they say Joyanagar Road.
No, but Bongaigaon Guest House. That's why I used that word Bongaigaon. No, I'm looking at
But
the
this is
synopsis.
pertaining to the Guwahati.
Guwahati, don't write Bongaigaon. IOCL, guest house and office complex at
6
Guwahati.
mile Guwahati.
Okay. The learned counsel for the petitioner submitted that as per her instructions, the petitioner as well as the respondent union in WPC 3804 of 2023 have had negotiations for engaging the unionized workers for as a part of their service. First of however, the agreement has not yet been materialized or finalized. First of
Actually, we had a discussion.
Oh, you had a discussion. Okay, don't write that. Don't write that.
At
No, it's
informal-
okay.
At informal level, my.
No. Then we don't. No, it's okay. Then we don't record it. Huh? No, it's okay.
I
Okay.
think my lord, the best way would be that they have undertaken to take this.
No, that I won't say.
yes.
Let them have this
Yes.
negotiation before the officer.
Yes,
Issue notice returnable in 2 weeks. Give a fixed date after 2 weeks. Returnable in so and so. Requisite extra copies of the writ petition be served on the learned instructing counsel for the respondent numbers for the respondents in WPC 6596 of 2023. Next para, having regard to the nature of service which is being rendered by the for which the petitioner has been engaged, the court permits the petitioner and the private respondent in WBC 3804 of 2023 to make an attempt of out of court settlement of the matter.
Settlement should be made to the petitioner and the VIP.
No, but you are a party. No, it will be before their officer. So hear my order. It will be before his officer. Unless you settle, the officer can't do anything. The said negotiation shall be held in the office of the respondent number. No.
One sec. Four, my lord.
Respondent number 4. And the outcome of the settlement proceedings shall be reported to the court on the next returnable date. Next para. The petitioner is also granted liberty to the to make a representation before the respondent number 4 for not issuing a for keeping on hold the tender process.
My lord.
She'll give a representation. We grant liberty to represent before respondent 4. No. But let her represent for not
No problem.
list on 29/11/20 just in notice. You also say issue notice, including notice on the prayer for interim relief. Returnable on so list on 29/11/2023. This certified copy you have given me, returning it to you.
3804 দুটা IA আছে।
This what is the IA in 3804 for? We just adjourn it. IS list on list on 29/11/2023. No. My court no, whatever my court master says is not disposed of, so therefore he must have seen it. Same day.
Production list item 2.
Just a moment. Just a moment. Give me 2 minutes. But if this is your nature of your prayer, why you not approach the police and lodge a FIR if there is a
I just find out the watching day 166.
166?
First is 127.
Yes.
This is the format manner agreement. They are all are supposed to submit. Now in my complaint number, where is that somebody has submitted and somebody has given all total. This is my complaint. So now we have taken query whether this is not mandatory. So there they say, madam, we have raised the query, the worship will kindly see 150, 154. So this, after the opening of the technical week, you are working note, any person they take an answer from the authority, they one it is something. So this is what, and if somebody files complaint, they initiate the procedure, they must come to a conclusion before opening of the candidate. For page 154, this is the query raised by us, further it is requested to kindly confirm whether purchase agreement for category 2 if the government's equipment are to be purchased, new needs to be submitted along the bill. Yes, purchase agreement is done. Reply is, this is the reply of the ONGC. Agreement is mandatory for category 2 and should be submitted along with the as a bid for the technical evaluation. Well, now your worship can see we have submitted this complaint at 166. And then the other complaints are at 156. So we have said, madam, that the purchase is some person, we have other complaints are also there. We have filed this and they initiated the process. Has come to our notice from our manufacturer that few participating leaders have misutilized the technical documents or manufacturer and have taken MOU with closing unit assemblies for fabricators closing unit assembly. Fabricators who do not have any experience of manufacturing such precise pneumatic closing parts. Whereas the part is 100,000 anything it is clearly mentioned that the purchase agreement must be made with pneumatic closing pump benefit. And these are pump where the crude oil is processed, is sent at a particular speed. So this is very important because if the thing goes down, weight loss will be to the area also. This is now you are watching, can you see 167? 167. This is the query raised by the ONGC to the manufacturer. This is our manufacturer. This is we have submitted their bids. First your version can be this is raised by the ONGC. Some of the bidders, number 2 your version can be some of the bidders have entered into purchase agreement with closing and the assemblies or like that, requested experience or credentials to manufacture some specialized building pumps. Now, reply your option can say that enclosing an observation sheet detailing the closing pump assemblers who according to our finding have entered into purchase agreement. We elucidates the lacking experience or credentials of these entities to manufacture their specialized closing pumps. Now, next page your worship is 168 observations. Number 1, in respect of one of the bidder, MOU from the so-and-so while this has presented an MOU from methods United International continuing to know that they primarily identify as a chemical injection system assembler over their manufacturer. They are saying that they are not considered. Similarly, in respect of another bidder, S3, page 169. So they have initiated the process. So they have found out that they got a reply that they are actually not the manufacturers. Some of the persons they have submitted bid, but without the proper manufacturing certificate. So therefore, we file another complaint before the chief vigilance officer because page 201 and 202 specifically showing after getting this reply, showing that SP smooth system and another one they are the purchase agreement is false. 201 you are working against 201 and 202. The previous complaint, my lord, page 202, you are also looking. 202,
Yes.
that number 5. Our vigilance complaint number for the earlier complaint which was filed by the petitioner that was numbered. So now, on the basis of this, they have to take a decision. They may reject it, they may say no, all bidders are good. Or they may say that all bidders are not good. Good reasons. This is what is expected, nothing else. Sir.
No, but they have held those bidders to be qualified in the technical bid.
Technical bid, ultimately, they have waited all this period. Suddenly I get a mail, a page 203.
So technical bid acceptance would mean that they were held to be qualified.
They are saying, madam, yes, well, this is what is, but what about the complaints filed by us, and what about the process?
They'll take a decision and inform you,
Yes, they
but for that we won't stay the tender.
saying, but they should take a decision on the basis of the complaint filed by us, because complaint filed by us has been initiated. They have initiated the process.
Okay, we'll issue a notice.
Some step. So therefore, the lordship, they may open the tender, but they should not take final decision. Let it come after 1 week, and it's just short matter, because it can be decided.
No, we don't know. We can't give a short notice because by the time you take steps, serve it. It won't be so fast. Huh. Okay.
They should not take final decision. Initially, they will take, suddenly on 13/11 of this month, they're saying no, you should go.
No, stay process after the Supreme Court judgments, plethora of judgments, saying the tender process. No. Yes. These are what do you call, very specific contracts. We don't know what would result. No. Now the Supreme Court has said that you can go and approach the civil court for compensation. Road is open. No. But you see, these are high value contracts. It's not a small contract. And then what effect will it have to the national infrastructure projects? We don't know.
Started from the ground of May.
No, I understand, but still, you see, these are oil pumping stations. So that's what it's done. Crude oil is being pumped.
Yes.
So pumping is a national interest.
Interest is there, but immediate necessity is there, because in the tender was quoted in the month of May.
No, I'm not staying. I'm not staying the tender process.
Hold it, but don't decide finally.
No. We will let it take. We'll say it's outcome of the repetition, but we'll allow this to proceed. No, not even for a day. Yes, that's fine. Heard Mr. Bididas, Senior Counsel, assisted by Mr. K. Kalita, Counsel for the petitioner. Next para. The case projected by the Senior Counsel for the petitioner is that the petitioner is a participant in the e-tender process for charter hiring of services for 39 numbers of chemical dosing system. This you will get in synopsis. Till 2023. Like full stop. At the stage of before the stage of technical evaluation, the petitioner had lodged complaints dated 12/7/2023, 27/10/2023, and 9/11/2023 through online portal, based on which vigilance inquiry has been registered. An inquiry has been initiated. Full stop. The grievance of the petitioner is that the complaint for vigilance inquiry has not been disposed of, but the but the techno-commercial appreciation of the bids have been made, and and bidders against whom complaints were made are held to be techno-commercially qualified. And the prize bid opening is scheduled to be held on 15/11/2023 at 15:30 hours. Accordingly, the learned senior counsel for the petitioner has submitted that till the vigilance inquiry is concluded, the either the prize bid opening be postponed, or the respondents should be restrained from taking any final decision to avoid the contracts. Acha, completion of the vigilance inquiry and furnishing of its report to the petitioner. Issue notice on, including notice on the prayer for interim relief returnable on in 2 weeks' time.
2 weeks.
The petitioner shall take steps in course of the day for service of notice on the respondents by registered post with AD. In addition, the petitioner shall serve notice on the respondent numbers 1 to 5 by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next para. The prayer for consideration of the interim relief shall be taken up on the next returnable date. Post the contract, when you awarded in respect of the aforesaid hearing before referred tender process, shall be subject to further orders that will be passed by this court.
412.
It's being made subject to outcome. It's made subject to outcome because we can't help it.
Why I'm saying because
No, that is okay, Mr. Das, but you see, based with this judgments of the Supreme Court, the only option I would have to reject your prayers. That's why I'm not doing it, but
what are the technical bid benefit open matter? If I find defecting somebody's bid matter, I should.
correct,
They take a decision.
correct.
This is the process.
Yes,
So this is what is happening. And the initiative in the month of May, they have also initiated, it is not that they have not. They say it or not, the agreement is mandatory. They say the agreement is mandatory. They raise query with the manufacturer. Manufacturer says some of the agreements have been for and it lacks some of the material. So there are some members, they should have one by, we have seen, we have found that nothing is there. So we find all the bidders are very, so that is what is expected, because as a tender or what do I expect, I don't expect anything. I have raised a very complaint, so that is the reason.
correct, correct. I'll see if I can make some additional subtraction in the order.
They should submit a report on the basis of the complaint finder. Whatever report they have made, or whatever results they have, something should be given to us. We must know what is going on.
Correct.
Now, hopefully, we'll get the order to.
Yes, I'll try to. But the difficulty is, Mr. Das, again, 315, we have to rise. There are 4 deaths in the lawyer community. We have to rise. Do it. I'll try to get it.
Item 9.
this matter, although an IA for vacating has been filed, but we have had a word, the main matter ultimately has to be heard. And the IA was filed almost 9 months after the stay was passed and the stay order was passed in their presence. Let the main matter be listed for admission hearing. Because hearing the IA will entail hearing the main, whole.
No, it's okay. If you are prepared to hear today the admission matter, we can take it up.
Fixed for the admission. No.
When you agree to a date, both of you.
Any date convenient coordinate next week.
No, so far as I am concerned, every date is convenient.
Let it be on 6th of December. Yes.
Or it is on 5th December, it will be a Tuesday. On 5th December.
5th.
In that case, let it be, if my learned friend is insisting on a hearing, then let it be 7th. There are 2 matters fixed in Itanagar on 4th. I may not reach back.
7th.
Okay, 7th. So this IA is by Union of India.
Yes.
Who's representing a union?
My friend, in fact, next.
NHIDC.
Achha, you are there. Heard. It's a PJ Segia, senior counsel, assisted by Mr. R.K. Talukdar, counsel for the applicants, as well as Mr. I. Chaudhary, senior counsel, assisted by Mr. S. Biswakarma, counsel for the opposite parties, obligate petitioners. Next, Pradhan. It appears to the court that the effort that would be taken in disposing of this interlocutory application, the connected writ petition can also be heard at the admission stage for the purpose of examining whether interim whether the interim order is liable to be extended.
The main matter should be heard for disposal.
No, I'm not saying disposal because I'm not binding myself. Correct. So I have to be very careful. Tomorrow, what I do is go to 23 matter. Keeping other matters, the tragedy is that all matters when it is listed yesterday, 14 matters were there. The council were not ready to argue the matter. And therefore, I had to rise at 2:15. So that is the issue. When we are ready to take up the matters, the adjournments will come, and when we want to adjourn the matter, then we have overburdened with cases. So, admission hearing, hand off for disposal, whichever convenient. Next paragraph, as agreed to by both sides, list on 7/12/2023. And release the connected repetition on 7/12/2023. Interim order to pass status stands extended till the next return of date. What is the subject matter? Okay. So what is the interim order?
Interim order is stay of
To hold it. Okay.
According to us, it is squarely covered by the
Gorkha security. Okay. Continue to hearing. Opportunity of hearing.
indicated
Okay.
that it will entail a penalty.
Okay.
Item 10.
Okay. My senior is on next in another court. Kindly pass over the matter for a day.
Yes, that's fine.
Okay, after some time. Yeah, let me see, Cal. Eleven.
Item 11.
Yes. Duplicate arms license.
See, after going to the petition, it seems that lordship, the license is already deemed to be lordship revoked lordship. So not renewed lordship after 2007 lordship.
It isn't revoked.
Deemed to be revoked as per the lordship by operation of the
Okay.
equity provisions lordship.
None appears on call for the petitioner. However, Mr. K. Gogoi, government advocate for respondent numbers 1 and 2 is present and submits that as per his instructions, as the arms license was not periodically renewed, there is deemed revocation of the arms license. Be that as it may, as the petitioner is unrepresented, matter stands adjourned today. List after 2 weeks.
Item 12.
Affidavit of the petitioner. Just a moment. No, you see, this, why I've opened this up is that previous order, the court has penned down that its opinion that without the employees being made parties here, the challenge would not be maintainable. So in that regard, what do you say? No, it's not made up. You have not been directed. You have just addressed us on maintainability of the repetition without the parties being there. You see, the fine was imposed on Anukumar Singh.
Yes, on personal liability.
Personal liability. Now that person is not even before us,
Yes.
and you have challenged that imposition of penalty.
Yes, on the petitioner is the transport company. Petitioner before your lordship is a transport company.
But on whom the this
Past is a personal liability in Anukumar Singh.
correct. So therefore, this court has rightly penned on this opinion that in the absence of that, you see, the personal liability has been paid, and the person on whom liability is imposed, he does not have any objection. So how will the writ be maintainable for you to challenge a penalty which has been imposed on the third party?
And because the notice was subsequently after 10 years, the notice was issued on the petitioner.
Where is that? Where is that?
Lordship. That is the one notice that has been issued on the petitioner lordship. Therefore, the petitioner challenge.
No. That is only a recovery proceeding. If that be so, it is only a recovery proceeding. In recovery proceeding, you being the employer, you have to show that the liability will not be payable by you. Because you see, that's an application denying liability.
Lordship, the order we have also imposed the order which has been passed as a personal liability to the Anukumar Singh. That was not passed in our.
No, you see, there are issues. You see, personal, this liability, which he has. Why an employer should not be made to discharge that liability? Because you can recover that amount from him. You see, it's a notice on the garnishee. If it's a notice on the garnishee, you are bound to accept it because the liability has not been denied.
The original order, the liability was not imposed on the petitioner.
No, you are not getting it. That's not the point which I am making. You see, what I understand from this order, let us say this, we take a very simple example. You see, in a Food Security Act, for food adulteration, a company is required to nominate some person as an authorized person to receive punishment. Correct. Now, in a food adulteration case or food safety violation, this person who has personal liability, on him certain what you call penalty is imposed. Now, if that is not paid, why the corporate against whom on whose person this personal liability was imposed can't be made to pay?
In that case.
You see, this is an excise. Excise, custom. So in a custom also, you have a designated employee.
He's not been specifically authorized. During the course of search and seizure, certain medicine were recovered by the respondent authority. And subsequently order was passed behind the petitioner.
Mr. Agarwal, that won't help you. You see, I've told you, there are reasons why I'm saying that. Number one, the person on whom this liability was imposed, he is not before us. So he has accepted the order imposing punishment on him or payment of penalty. Now, you being the corporate employer, why should we hear a petition denying liability at the writ petition stage? Even in the Customs Act, you have provisions for denying liability of recovery.
When the order was passed at the relevant point of time, there was no within the knowledge of the petitioner. The both in the 200, kindly produce the petition and the enclosures.
That's the same argument placed on last occasion, and this honorable court come to a conclusion that in absence of employee.
It will not be maintainable.
It cannot be.
It will not be maintainable. No, it is for you. You'll have to file an application. We'll allow it. But that is why. You see, petition denying liability is can't be adjudicated in a writ petition as an original application. Please bear it in mind. You may do that exercise, but even after 4 weeks, your opinion remains the same. In an adjudication under the Customs Act or any other act, even under the Bengal Public Demand Recovery Act, the requirement of law is that the recovery can be made from anybody from whom it can be recovered, and it's an application denying liability to the person on whom notice is issued. This notice is issued to you in the what you call. Since I'm more conversant with CPC, I am using the word garnishi, and in that in your Customs Act, the recovery says from any person who owes liability. There's some language difference. So if that is imposed, first is that you have to satisfy the court that it's or the authority who is making the demand, raising the issue of denial of liability. So therefore, it is a 2018 matter. Even if we postpone it, nothing material will come out. Please take a call on that point also. Both sides are. Just say Mr. S.K. Agarwal, counsel for the petitioner, as well as Mr. S.C. Kyal, counsel, standing counsel for the Customs, an expert on the prayer made by and counsel for the petitioner. Matter stands adjourned today, so as to enable him to do the needful. Item 11. কি কৰিলো order?
Item 11 হৈ গৈছিলে list of police.
Show me that if the respondent is available. Who is for the respondent? Oh, you are there. Yes, arms act. No, it's okay. But your arms is there's a deemed what do you call expiry of your license. Arms Act. Arms rules.
Overruled by 2016 rules. Yet 68 rules, which was referred by my friend, 58 rules. It was
No, it's not 58. It is now 2016.
16, it was.
That's why I said 2016.
28.
Section 28. Section 20 is punishment. You are referring to Rule 28.
20, 28.
No, you are not getting us. What I said to you was the submission made by Mr. Gogoi that your license was not renewed. And after a particular period, there is a deemed revocation of the license. So once the license is revoked, the question of issuing a duplicate will never come.
Not there is that we issue the
You see, expired license, you don't get a duplicate.
certificate signed with my by letter and approximate and certificate number and one to make it. There's only 8 numbers.
Page
Is 8.
8. Just one. Yes. Yes.
There is an 8 number, fourth line, duplicate arm license. Catering state. Catering state number, at this point of time, it could not be issued, it indicates that it can.
No, I don't know the purpose of this repetition. The letter says instead of duplicate, you apply for a fresh license, and you are not doing it. Why? You want to duplicate, they are willing to give you an original license, and you say no. That means there is something fishy. That means you don't want a police verification again. You don't want you to be subjected to any inquiry. And why will somebody who is trying to own an arms license will not subject himself to an inquiry? It's okay. They are willing to, you see, they are not saying they will not give it to you. They say that we'll give you the original. You apply for an original, we'll give you. No, but tell us. We doubt your credibility now. No, but how does it change? You see, Mr. Ali, how does it change the situation? You are an arms, you're an ex-serviceman, but their authorities are willing to give you a new license. Is there any difficulty in getting a new license? What sort of? It's okay, but tell us what prejudice you will suffer if you get a fresh license. What happens? No, it's okay. You tell us. I am asking you a question now. If the authorities are willing to give you a fresh license, No, but why you are insisting? Why this repetition? Why you are insisting that you should be given, there should be some compelling reasons. No, that's okay. You see, for example, I would have been happy if my, just say, driving license was 0007, 007. With 007, I can relate myself to James Bond. So I say that no, I don't want a fresh license. I want this 007 because I'm happy with this James Bond number. I must have some reason that I don't want a fresh one. I want the old renewal of the old one. So in this case, what is so sacrosanct of that old license that you want a renewal of the license or not a fresh one? And this repetition. So how does it matter to you? What you need is an arms license. No. There must be some reason. There must be some hidden reason. Otherwise, your conduct becomes questionable. You see, I am now I am questioning your credibility. Why you need a? Why you are insisting on a? You see, I could have understood that they say that no, once license is lost, we will not give it to you. They said, according to us, your license is lost. You apply for a fresh one. We will give it to you. And against that, you have come to a writ court. The matter is pending since 2018. A license which could have been given to you within a month is now taking us 5 years. And still the court is not satisfied with your credibility. It's a misconceived petition.
Even Lordship, today also Lordship. Address of the petitioner is for the Aurangabad Lordship, it is under the Uttar Pradesh Lordship. As per the rule 24 Lordship 44, we are not the authority to even renew also Lordship. Change of address Lordship.
Where is that?
24 Lordship. Rule
Section, rule 24.
Rule 24 Lordship. Even renewal part also today we cannot Lordship.
Where is your copy of your license? Where is the statement that this license is renewed up to which? Because I find here in page 21, renewal up to 31/12. This is something I can't read. 31/12. No, it's okay. But what is the date? 31/12. Which year? Page 21, that annexure 1 of your additional affidavit. What is the date? This is something I can't read. 31/12. No, it can't be 93. It is renewed up to, your original license is up to 93. This is up to when? The licensee notifies change of his residence permanently or temporarily for a period more than 6 months to the licensing authority of the district in which renewal is sought. The licensing authority of that district shall thenceforth become responsible for watching all future renewals of the license.
Even Lordship, section 15 says that Lordship, the amendment act of section 15 says that it will be for the 5 years Lordship. Section 15(1) Lordship.
15,
15(1) Lordship.
1, license under. Private is transfer necessary for it. Conditions of.
Continued force for a period of 5 years by its amendment of 2019 amendment. Lordship. Earlier it was 3 years Lordship. The pleading shows that Lordship, there is no any renewal Lordship. Then Lordship, by operation of rules section 15(1) Lordship, it's going to be revoked Lordship.
Where is the document of surrender of your arms? If the armed license is not there, you have to, there's a requirement of law to surrender your arms. Where is the certificate of surrender? Mr. Ali, we are closing this petition and we will permit you to apply afresh. In your, what do you call, in your hometown, not here. But Mr. A. Ali, learned counsel for the petitioner. And Mr. K. Gogoi, learned government advocate appearing for respondent numbers 1 and 2. Next paragraph. The petitioner is an ex-serviceman. Having discharged from Indian Air Force on 31/3/2007 as sergeant. Full stop. The petitioner projects that the arms license as an ex-serviceman makes him entitled to re-employment in civil sector. Full stop. The petitioner claims that on 24/7/2017, the original copy of the said arms license along with some other important documents were lost in Gautam Budh Nagar district of Uttar Pradesh. And accordingly, he had lodged an FIR which was registered as crime number 243 of 2017. Full stop. However, the concerned police station of sector 49, Noida, Gautam Budh Nagar had filed a closure report, final report, number 58/2007, dated 2/8/2007, which was accepted by the concerned court. Full stop. Thereafter, the petitioner submitted various representations to the authorities for renewal of his arms license. Full stop. Thereafter, by the impugned communication dated 16/8/2013, the Deputy Secretary to the Government of Assam, Home within bracket C bracket close Department within bracket respondent number 2, where is that? Where is that order? Page 17. Where communication dated so and so. Addressed to the District Magistrate Bulandshahr, Uttar Pradesh. Requested the District Magistrate Bulandshahr, Uttar Pradesh to issue a fresh arm license to the petitioner after observing all required formalities as per the guidelines of Ministry of Home Affairs. And in the said communication, the loss of the arms license and final report by the by the and a report by the District Magistrate Gautam Budh Nagar, UP was referred to. Next paragraph. The learned counsel for the petitioner has submitted that under the provisions of Rule 28 of the Arms Rules, 2016, it is permissible for the authorities to issue a duplicate license in respect of license which is lost or accidentally destroyed by on payment of fees with which the original license was chargeable. Accordingly, it is submitted that as there are provisions in the Arms Act, 1959, as well as the Arms Rules, 2016, providing for renewal of the arms license, the non-renewal of the license of the non-issuance of a duplicate license to the petitioner infringes his fundamental right. Hence this writ petition. Next paragraph. The learned government advocate, additional senior government advocate has submitted that under the provisions of of Section 15 of the Arms Act, 1959, license is issued for a period of 5 years, which was earlier 3 years. And the renewal of license, and that for renewal of license, application, time-bound application is required to be submitted. Full stop. It is submitted that in view of the provisions of subsection 1 of Section 15 of the Arms Act, 1959, there is a deemed revocation of the license, which has lapsed by efflux of time. In this regard, it is submitted that in the writ petition, there is no averment that the arms license of the petitioner was renewed from time to time till the present writ petition was filed on 10/4/2018. Full stop. By referring to the provisions of section 24, rule 24 of the Arms Rules, 2016.
Parliament, rule 17 for a moment, rule 17.
17.
17. Page 41 or so.
Okay, by referring to the provisions of rules 17 of the Arms Rules, 2016, it is submitted that if a person who holds a license permanently or temporarily shifts to a new place of residence for more than 6 months, he is required to send intimation about the change of address to the licensing authority within a period before expiry of 6 months. And the license is required to be produced before the new licensing authority by applying in form capital B dash numerical 1 and indicating the place of his new residence. Full stop. In this regard, he is also the government advocate has also referred to the provisions of Rule 24 of the said 2016 rules. Wherein it is also provided that the application for renewal, in case of change of place of residence, would be the licensing authority of the district, who, under proviso to sub-rule 3 of Rule 24, becomes responsible for watching all future renewal of this license. Full stop. Hence, it is submitted that as the license of the petitioner, arms license of the petitioner has expired by efflux of time. There is no infirmity in the order of the respondent number 2 in requesting the district magistrate Bulandshahr, Uttar Pradesh, to issue a fresh license to the petitioner. Next para. The court finds force in the submission made by the learned additional senior government advocate that to the effect that apparently from the contents of the writ petition, it cannot be said that the arms license of the petitioner was in force on 10/4/2018, when the petitioner had approached this court by filing this writ petition. Full stop. Therefore, if the arms license is not in force, a question of issuance of a duplicate thereof to the petitioner would not arise. Full stop. It is also seen that the respondent number 2 had, by the impugned communication dated 16/8/2013, has requested the district magistrate Bulandshahr, Uttar Pradesh, to issue a fresh arm license to the petitioner after observing all formalities. Full stop. This amounts to a no objection from the state of Assam to the district magistrate within whose jurisdiction the petitioner is was then residing, because as per the said communication dated 16/8/2013 by the respondent number 2, the petitioner was a resident of village Mahmood, MAHMOODPUR, PO Aurangabad, district Bulandshahr. Full stop. As the law prohibits the district magistrate within whose jurisdiction the arms license holder is not residing to renew the arms license, the court finds no reason to interfere with the impugned communication dated 16/8/2013. Next para. In the event, nonetheless, in the event the petitioner applies before the respondent number 2 for issuing a request to the competent authority within whose jurisdiction he is presently residing, the respondent number 2 shall consider the said application of the petition and pass appropriate orders thereon. Subject to condition that the petitioner shall return the impugned communication dated 16/8/2013 within bracket Annexure G, bearing memo number capital HMM-20/99/397 to the said authority. So with the aforesaid observation, this writ petition stands closed. Item 13.
Is the executive demand also because the executive demand has been submitted by the executive.
2018, now it is 2023. Now you have submitted demand. Who pays interest?
In the probability of non-availability of fund, it was not paid earlier also.
No, I
Yes, demand
understand.
has been submitted.
I understand, but you are taking what you call advantage of your superior bargaining position. You extract work from some person, he does work as per your satisfaction, and then you don't pay him. It's a work order which year? He must have done a lot of shoe polishing to submit his bill.
Earlier, bill was submitted due to non-availability.
No, I understand, but what happens to the interest? Just tell me. 5 years, 18% is good enough. In arbitration, we have 18% interest.
Lordship, there is a clause in the agreement itself, Lordship.
No, I understand, but No. Does your agreement say for 5 years you will not pay no interest? Did you give them a reasonable information? Was it a F2 form of contract? What was the nature of contract? Assam government normally does F2 form of contract. Was it? It's not available. No, but what about interest? What happens to the petitioner? I'm asking this question for a particular reason. Because in my today is incidentally the 7th year of my elevation. 15th of November. Today is the day. And I've not seen a single big time contractor whose names are very prominent approaching the court for contractors' payment. Except prominent lawyers are there behind your back, most those matters. But prominent contractors I have not found. So therefore, you are having a class distinction.
Lordship may observe all these things, Lordship, by
No, I'll issue notice. I won't observe ex parte. I'll issue a notice to your what you call to your department. Why this observation should not be made? I must give them an opportunity of hearing. Otherwise, you'll accuse me that this observations was made without notice. So I'll issue a notice. In the meantime, you process these papers. Heard, Mr. N. Thakuria, counsel for the petitioner. Mr. N. Upadhyay, and standing counsel for the Irrigation Department, has submitted that as per instructions received by him, the what is it called?
7,89,000.
No, what is that?
This is the demand.
The demand for the contractor's bill of the petitioner has been made to the competent authority. So it is submitted that some time would be required to process the payment. Next para. In this writ petition, it is projected that the formal work order was issued on 5/11/2007 and completion certificate was issued on 21/10/2010. And the petitioner is to receive the security deposit amount of rupees 2,43,395.
The bill value was 17,28,668.
No, he's not claiming that. He's claiming only, and he also claims outstanding contractual bill of rupees 7,89,262. Stop. Next, from the above narration, it appears that the bill of the petitioner is now being processed after a lapse of 13 years. Full stop. In the experience gathered so far, the court has not found very that all the contractors who have done work in the irrigation department had to approach this court for their contractual dues. So therefore, it appears that the respondent authorities are creating two classes of contractors. First, which are required to come to court to get their outstanding payment, and second class, who are paid without any demur and without requiring them to litigate for their contractual dues. Next para. Therefore, when there is a class discrimination by the irrigation department in payment of contractor's bill, comma, the court is of the considered opinion that non-payment of interest to such contractors who are deprived of payment of their dues within a reasonable time would become entitled to some interest. Full stop. The learned, next para. In this regard, the learned standing counsel for the irrigation department has submitted that there is an exclusion clause for interest in the contract agreement. Full stop. The said submission is considered. Full stop. However, we do not find anything in the contract agreement which says that a person will have to wait for 13 years. The petitioner was given notice that he would not be paid for a period of 13 years. And with that prior intimation, a clause of exclusion of interest was inserted in the contract agreement. Full stop. Under such circumstances, the respondent authorities in the irrigation department are put to notice that why the exclusion clause of interest would not stand as a bar for the court to award interest, a reasonable interest to the petitioner for withholding his payment for 13 years, and why liberty should not be granted to the state to recover the interest amount from the officials who are found guilty of not possessing the payment of the petitioner in its right earnest. Next para. The court also issues notice to the respondent authorities, including the Secretary to the Government of Assam, Irrigation Department, to show cause as to why the Irrigation Department is not maintaining a register as was directed by this court in the case of, where is that, which is that case? Tamsher Ali versus, what is the citation?
2008 for GLP 1.
2008 for GLT page 1 versus State of Assam. To maintain a list of contractors whom payments are due and proceed to make payment in serial order. So therefore, on the next returnable date, comma, the respondent number 1 shall place before this court the list of unpaid contractors register. The register of unpaid contractors, in accordance with directions issued by this court in the case of Tamsher Ali within bracket Supra. Full stop. The state is further put to notice that non-production of the list will invite presumption from the court that the list as directed by this court has not been maintained. And appropriate orders would be passed in this regard. Next para. The standing counsel for the Irrigation Department shall forward a downloaded copy of this order to the Secretary to the Government of Assam, Irrigation Department, so that the authorities, the respondent authorities in this case, file their response to the show cause notice positively on the next date of listing. Next para. The pendency of the repetition shall not be a bar for the respondent authorities to clear the payment or due to the petitioner before the next returnable date. List on. After 4 weeks, give a date. After?
He wants the date in the month of January.
Okay, in the month of January. list on so and so as prayed for by learned counsel for the petitioner. Date of the we don't have the calendar of January right now. We'll give it later on. The court master will give a date later on. Yes, item 14. Yes. Yeah, just one moment. Yes, exercise, what do you have to say?
Lordship, an inquiry was conducted, Lordship, and in the inquiry, we have received NOCs from the residents residing within the vicinity of 75 meters, the Lordship. What do you do, your Lordship? Most of the evidence is not on record, your Lordship.
What you call that inquiry report is under my carpet.
No, your Lordship.
Where it is?
I will file it, but it's not read. I've checked it, your Lordship.
Okay, you filed it.
Yes, your Lordship, fine.
Day after tomorrow, this on Friday, along with the affidavit filed by the respondents on. Where did you file it?
10,
On
11.
10/11/2023. Okay.
All right.
This is 15. Yes. 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 So every day is a disposal day for us. It's for you to start your argument. That's okay. But here, every day is a hearing day.
We have filed the affidavit on
At motion stage, admission stage, order stage, what you call hearing stage, every time we hear. Yes, what is your stand? Respond number 6, what is the stand?
Our stand is that, my lord, there is a scheme, my lord, NLCPR scheme of the Ministry of Honor, my lord, and it is a time-bound program. The petitioner could not complete the work within that period. Subsequently, the scheme was closed. Central government did not release the fund. And my lord, the central government has not been made a party in this particular petition, my lord, and without receiving any amount from the central government, the autonomous council is not in a position to make any payment, my lord. Subsequently, that
Okay.
work was, my lord, executed by another contractor, was allotted by the government of Assam, and the work was completed in 2021 by another contractor. And at this stage, my lord, the work executed by the petitioner could not be verified also.
Could not be verified, but
Well,
that can't
at
happen.
this point, after work was executed of the 2009 and 10, after 13 years, they have filed a petition, my lord, claiming the contractual bill, my lord. And whether the petition is maintainable or not, my lord, that point also lords may consider it, my lord, in view of the recent judgment pronounced by the Supreme Court, my lord. We have already filed that judgment, my lord, in the.
No, that we understand. But you see, the government, when it issues a fresh work order,
My lord.
that was within the currency of the earlier scheme or after the expiry of the
After
earlier scheme?
when the scheme was, it is of 2009 and 10, my lord. And that it is required to be completed within a period of 18 months.
Okay. Miss P. Das, counsel for the petitioner, case for an adjournment. Next para. Mr. J. Sudhya, learned standing counsel for the KAAC, has submitted that the
In person.
the respondent number 6 has filed an affidavit in opposition.
6, we have already filed, but the court direct us to file the affidavit on behalf of the head of the department, additional 6 in here, by order dated 19/2023.
Okay. Affidavit opposition on 30/11/2022, as well as an additional affidavit on 31/7/2023. Full stop. He is, upon instructions, comma, he has submitted that the the contract work allotted to the petitioner was for the improvement of page 19, huh? The improvement of so and so. For the year 2008-09 under so and so. Huh? It is submitted that the said project was a centrally was under a centrally sponsored scheme, and therefore was to be completed in a time-bound manner. Full stop. It is further submitted that, as per his instructions, the petitioner could not complete the work, and therefore
Within the time.
within the allotted time, and therefore the funds which were to be released from the central government had got lapsed. Full stop. It is submitted that resultantly the state government, under its own funds, had completed the balance remaining work. It is also submitted that the work related to the year 2008-2009, but the petitioner has approached this court by filing this writ petition on 16/3/2022, and that after a lapse of how many years it will be? 8, 9, 9, about 20 years.
And 13 years.
13 years, okay. 13 years of completion. No, 2008,
8, 9.
9.
Now 23, my lord.
Oh, acha. Sorry, 8, 9, 13 years. Comma. He's instructed that it is not possible to verify the extent of the work done by the petitioner.
So the amount
Next
could not be
paragraph.
admitted.
Huh?
So the amount could not be admitted. You could not admit the amount that it is due.
It's okay. We said that you're not doing it. Not doing it. Next paragraph. It is also submitted that as the petitioner is claiming payment against work which was under a centrally sponsored scheme, comma, the respondent authorities are not in a position to commit any payment, and therefore, and as such, it is submitted that the central government and its concerned authorities are proper and necessary parties who are required to be implicated in this writ petition, and in whose absence the writ petition cannot be decided. Next paragraph. The learned counsel for the petitioner shall take note of the submissions and address the court of the issues raised. Matters is adjourned today. List after. After, no, we're making it 2 weeks. After 2 weeks. This was 15. Item 16.
Similar.
Same. Okay. Similar. You are appearing for 1 and 3 government. Your name? M. Das, government advocate for 1 and 3.
Standing
Oh, standing also PWD. Okay. And Where will I find the name of the work here?
The same road, my lord.
Huh?
Same road,
Same work.
same work. It was divided into different groups, my lord. The petitioner number one, my lord, he was allotted 3 works, other petitioner 16, 13 works he was allotted. And petitioner number
6 work orders. To this petition, 6 work on the same tender. The same scheme. And to the earlier petitioner was
he was allotted 3 works.
3 works.
3
Okay.
works. And petitioner number, my lord, that item number 16, he was allotted 13 works.
No, 6.
Altogether 13 works were allotted to him, my lord.
No, in synopsis page number 2, he says 6 works.
We have clarified in our affidavit, my lord.
No, but I don't know. What is he? What is it?
They are contention, my lord.
What I see is what you get.
My lord, my lord.
If it is wrong, please tell us. We'll correct it, because otherwise very difficult to correct the orders thereafter.
My lord.
See synopsis page 2. Synopsis page 2, last about 6-7 lines. It be it stated that all these efforts is 6 numbers of works. I don't know if it is
The
13.
authorities has made part payments.
6 works.
6 shows part payments.
So where is the where is 13? Where is 13?
Is 2.
No.
Synopsis.
Where is 13 works? It is 6. All 6.
My lord, in our affidavit today, my lord, we have stated that altogether 13 works were allotted to the petitioner.
13 works. So you want to pay him more. Dil mange more. Which is that advertisement? Dil mange more.
15 works, not 30.
Which
15,
is
15 works.
15
The
works.
respondent disputes the completion of all the 15 work allotted to the petitioner.
Which is that advertisement? Dil mange more. Pepsi. Huh?
I'm putting item 10.
10. John Matter. Yes.
If the petitioner is asking for enhanced subsidy.
Yes.
We have paid them on the basis of earlier. I was directed to produce the record. On last occasion, this one was directed to produce the record. A record with not the 30 years. There is no discrimination, and it was rightly paid to the petitioner. They applied for 2. They have to appropriate the tree bushes and plant it again. They file in one application. They have
No, their case is very simple. They are referring to 12th plan.
not said.
And they say that 12th plan, the allocation was increased.
Not said, but it was started earlier.
I don't know. This is what I.
See,
But it says that, however, while sanctioning, you sanction a lesser amount. That is his claim.
yes, that is their claim.
Yeah.
But in our affidavit, we have clarified, and in the original record also, and we have given to the other tea gardens also the same rate. But the-
No. You see, you could have given XYZ money to others. But but whether the claim under the scheme is right or wrong, you show us the scheme.
What's it that that is available in the record? And,
No. You see, for me to verify the records will take days and years. By the time I superannuate, I will be able to look at this record.
I have prepared one not Lotsie for Lotsie.
No, but you see, I'm not asking that. You see, the petitioner says that there's a 12th plan.
Yes, Lotsie.
And in the 12th plan, he says that the allocation is at a particular rate.
They are asking for that. Lotsie.
So, but you'll have to show from these records.
Yes, Lotsie.
You look at this record and tell us what is the rate approved.
It was Lotsie, actually they were they applied for 2 sanctions for 16 and 25T.
One application in the year. Those 2 blocks of land approved and replanted before the plan came to us.
That I cannot dispute. Clause 16, your lordship, was applicable in replanted at the same earlier rate of 89,000.
650 per hectare.
That is not what happened eventually was that your lordship 25B, consisting of 18,140 hectares, that same would not be done, and that replanting and uprooting it took place during the term of the 12th plan. The 12th plan increased the subsidy from 89,000 to the new which is 1 crore 90,000. That is our case. That
No, for that, then the situation changes. You see, if you are applying for a plan of a previous year in the current application, have you applied for that and sanction was given?
sanction.
Where is that?
Sanction was- There are two entities. One I was in the page 55. Page 55. Dear sir, certain pre-application dated student and subsequent PA election dated so taken by the office. I am to inform that there is no section here commencing the approving the below entered section under the board special purpose in part at your interest and simply all the terms and conditions of the scheme. The lordship sees the section 16 and 25.
No, you see, here there is an issue when you make me read the documents. At page 55, look at clause 1. A declaration and submission in the last 4 lines. Return regularly to the T-board, past performance report under so-and-so, 7 years so-and-so. And before that, you see, it may be pleased to note that NOC is being issued with an object to enable you to commence and do the fieldwork within time limit without any financial commitment on part of the T-board at this stage. You see, what happens is that in a tea garden, there are various stages where you have to take permission from the tea board for various activities. So if it is replanted, then they say that you do it, but there is no financial obligation. Therefore, they are not committing themselves to make payment of the subsidy under the scheme.
That's subject to participation. That because they're not voted. Now, what has happened, subject to elections, like pursuant to which NOC, there was one clause, because replanted and uprooted to be done at the earliest stage. That is not in this. What has happened?
No, you'll have to show us completely. You see, please go by sequence because otherwise I'll miss it.
Yeah.
I may be saying something from here and there, but it won't make a sequence. Under the T-board regulations, if it is a new land, you have to take permission. If you are having a uprooting and replantation, you have to take a permission. And then the change of the nature of plantation or the manner of plantation will also require a permission, separate permissions. So therefore, now that is the first part. The second part is that the additional land, if you are saying was used, then also you'll have to take a permission, and then again this permission, if there is a subsidy involved, you'll have to tell us about that. Please go in sequence, otherwise I may miss out. 57. 57. Oh, just on. I'll have to rise. 215, I have to rise. This is a reference.
Yes.
I'm sorry. I forgot that. Just tell the courtmaster will extend it. Just tell the courtmaster will have to give a shorter because I can't oversee it. Tell the courtmaster will manage it. Just give a date, shorter date in case. Content matter. Item number 49. Okay, content issue notice. Pendency shall not be allowed. What is the date of non-compliant? Which order is non-compliant? Order dated?
Order dated 26, 22/12/2022.
12/22. Okay, within time. Okay.
About my senior assembly.
One by one.
Item 49, lodgement and report of senior thing. Mr. H. Gupta. Upon instructions.
You want to withdraw it?
No. Item 49, contempt.
Huh. You are accepting notice.
Lordship, my senior, you may record my senior's name.
Tell him, tell the lawyer. Get the lawyer.
Maybe. Item 18, your lordship.
Maybe fix on 25.
He'll do it. Fixing of dates or extension of the orders, the court martial will do it. Then the court martial will do it. I was just waiting for the lawyer. He said it'll come. Give it after a week. This matter. In that case, if the lawyer comes, if he accepts notice, he will take it. Record his name, accepts notice on behalf of the. But it is very strange. Somebody coming in contempt and saying that I am receiving notice. Very strange. Doesn't happen normally. Record the lawyer's full name. Full name and the what you call bar registration number. Mr. Mathai, anything? Please take it because I have to rise and go. There's a reference today. Mr. Das, I'm sorry, I noticed you late. Please come forward. Item? 25. Okay. When do you want? Because today reference we have to go early. When do you want the matter to be fixed? Next week we'll give it. That's accommodating next week. Huh? We'll give you a date. Give a fixed date for him. And if that lawyer comes, just ask him.